Hi everyone, and welcome to this morning's NILF webinar, Immigrants' Rights Updates. We're going to go ahead and get started, but first let's go over some housekeeping matters. Everyone who's listening in is on mute and will remain on mute for the entirety of the webinar. Please send us any questions you have, as you have them, through the chat box function on the right-hand side of your screen. Nina Torres, our program associate, will be collecting all of your questions throughout the webinar, and we will save 20 minutes at the end of the webinar for the panelists to answer your questions. If you have any technical issues, please also use the same question box function to let Nina know, and she will assist you. This webinar is being recorded and will be distributed via email to everyone who registered, along with a PDF version of the slides on Monday morning. Now I would like to introduce today's panelists. First, we'll hear from Angelo Mathey, Senior Research Associate in our DC office, about the Congressional budget. Next, we will hear from Gabrielle Lassard, Senior Policy Attorney in our Los Angeles office, regarding public charge. Then we'll receive an update on the Muslim and Refugee Ban Executive Order 2.0. NILC's Legal Department Director, Karen Tumlin, will speak about litigation challenging the Muslim ban. And then we have a special guest today, Matt Adams, the Legal Director of the Northwest Immigrants' Rights Project, joining us from Seattle. Matt will speak about the Washington case. And thank you very much, Matt, for joining us today. Finally, Staff Attorney Alvaro Huerta here in our LA office will update us on Louisiana marriage case. After all the panelists speak, I will be asking your questions to the panelists. And with that, I'll go ahead and pass it off to Angelo.
Good morning, everyone. My name is Angelo Mathey, and I'm a Senior Research Associate here at the National Immigration Law Center. Today I'm going to go over a brief overview of the federal budget process, discuss where we are in that process, and specifically go over President Trump's supplemental budget request for fiscal year 2017 and his budget blueprint for fiscal year 2018, and end with a call to action. Next slide. As many of you already know, the federal budget process is a complicated one. Many forces shape the federal budget. Some of them are forces written into law, like the president's role in drafting the budget, while other forces stem from the realities of our political system. Overall, the budget process has evolved over time, and today there are 5 key steps in this process. First, the President sends a budget request to Congress each February for the coming fiscal year, which begins on October 1st. Because this is the only step that has occurred thus far, I am not going to focus on steps 2 through 5, but wanted to have them up for your reference. Next slide, please. Under this first step, President Trump released a budget blueprint for fiscal year 2018, outlining increased military spending and cuts across other agencies, including the Environmental Protection Agency and the State Department. On the same day as his budget blueprint, President Trump also asked Congress to consider a supplemental budget request for fiscal year 2017. The request included an additional $30 billion for the Department of Defense and $3 billion for the Department of Homeland Security, which I will discuss in the subsequent slide. Notably, the President did not propose any offsets for the increased fiscal year 2017 funding. Rather, he recommended that Congress identify $18 billion in non-defense discretionary spending cuts as they finalize their work on the fiscal year 2017 spending bills. Finding $18 billion in spending cuts will only further complicate Congress's race to finalize the remaining 11 fiscal year 2017 spending bills. This supplemental request has received opposition even from Republican lawmakers who've stated that it's a little bit too late to include the supplemental request in the fiscal year 2017 appropriations legislation. Next slide, please. President Trump's fiscal year 2017 supplemental budget request includes $3 billion for the Department of Homeland Security, a majority of which would fund a new wall along the southern border, more Border Patrol and ICE agents, and expanded detention facilities. In this breakdown, you can see that Trump wants Congress to approve $1.4 billion for the border wall in the current fiscal year, which is in my opinion, an absurd waste of taxpayers' money. Next slide, please. Trump's supplemental budget request also included a $1.2 billion request for ICE operations and support to pay for detention, transportation, and removal of undocumented immigrants, additional hiring of ICE agents and officers, and support for the expansion of the 287G program. What's more alarming in this request is the potential funding for a data integration system that would support immigration enforcement operations. We are fearful that these efforts to achieve real-time data integration could be harmful for undocumented immigrants and their families. Next slide, please. Moving forward with Trump's quote-unquote skinny budget, he continued to seek funding for both the border wall, border security, and expanded detention, transportation, and removal of undocumented immigrants, similar to his fiscal year 2017 request. Additional signs that Trump will continue targeting undocumented immigrant communities can be found in his request for $15 million to begin the implementation of a mandatory nationwide use of the E-Verify program, which we believe would be too costly for employers. Requiring employers to use E-Verify will devastate agricultural employers and will cost people their jobs. Next slide, please. In addition, Trump's skinny budget further criminalizes undocumented immigrants and wastes billions of dollars by requesting funding to hire 75 additional immigration judge teams to adjudicate removal proceedings, provide 60 additional border enforcement prosecutors and 40 deputy U.S. Marshals for the apprehension, transportation, and prosecution of criminal aliens, hire additional attorneys to obtain the land necessary to secure the southwest border, and secure additional detention space for those awaiting trial or sentencing, while at the same time cutting resources for other immigration processes and for localities that have adopted immigrant welcoming policies. Trump is also undercutting the refugee resettlement programs and visa entry programs to effectively ban the entry into the U.S. of certain people based on their religion. Next slide, please. Overall, Trump's proposal would shortchange a wide swath of services and programs intended to improve and protect the lives of working class Americans, including educational, cultural, environmental, and safety net programs. All told, the Trump administration asked for more than $7.5 billion to help enact his mass deportation agency and to start construction of a wall along the U.S.-Mexico border. Next slide. As such, we ask all of you today on this call to tell your members of Congress that you oppose Trump's deportation force. On this slide, we have a link to identify your members of Congress and a sample script for you to use during your call. Lastly, we urge you to join an indivisible group near you and become part of the larger movement to stop the Trump administration from enacting regressive policies and laws. Next slide.
Thanks, Angelo. And next, I'll pass it along to Gabrielle Lessard, Senior Policy Attorney here in Los Angeles.
Good morning, everyone. So the slide says public charge, but I'm actually going to be talking about a leaked executive order, not signed yet, an order that was leaked by Fox, the media site, in January that touches on a number of public benefit issues. We're focusing on public charge because it would create a significant change in long-standing policy about the public charge grounds of inadmissibility. So just as some background, as I said, public charge is the grounds of inadmissibility. That means a person can be denied entry to the country. They can also be denied the ability to become a lawful permanent resident or green card holder if they were determined to be likely to become a public charge. A public charge is a person who is primarily dependent on the government for subsistence. So in looking at whether a person is likely to become a public charge, the statute requires that either the consular official evaluating a person's application abroad or immigrant official evaluating a person's application for LPR status here look at a number of factors that affect the person's ability to be self-supporting, including their age, resources, health, education, income, skills.
Can all of the presenters please put themselves on mute?
Sorry, folks.
All right, thanks.
All right, let's try that again. So this public charge test is statutory, meaning that it can't be changed by executive order, and requires that the person evaluating whether someone is likely to become a public charge evaluate multiple factors that relate to the person's ability to be self-supporting, including their age, resources, health, education, income, skills, prior employment, and whether they have a person who has signed an affidavit of support on their behalf indicating their willingness to be the person's sponsor. No single factor is determinative. And even though we think about public charge as involving public benefits, note that the statutory test does not address public benefits. So under current policy, and this is under guidance issued by the INS, and which was the predecessor to USCIS in 1999, only 2 public benefits can be considered in a public charge determination. Those benefits are cash assistance for income maintenance and institutionalization for long-term care at government expense. Non-cash benefits like SNAP as well as Medicaid for purposes other than institutionalization, and cash benefits for other purposes such as short-term cash for emergency purposes can't be considered in a public charge determination. And just to reiterate, this is the policy now. Nothing has changed. So what the leaked order would do is it would rescind and replace that 1999 guidance. And instead of limiting the scope of consideration to the 2 benefits I described, it would require that the benefits considered in a public charge determination include all public benefits for which eligibility or amount is determined in any way on the basis of income, resources, or financial need. Since the order hasn't been signed yet, we don't know whether this means what we think of typically as federal means tested public benefits like TANF, SSI, SNAP, Medicaid, and CHIP, or whether it could be even broader and reach such things as the WIC program or school lunch. The order also directs rulemaking on the part of several agencies, including directing the Department of Homeland Security to issue regulations that are consistent with the new scope of benefits, including regulations that would require immigrant sponsors to repay the cost of benefits that were received by their sponsor's immigrant in a way that's consistent with that broader definition. The leaked order would also require federal agencies that grant benefits to pursue sponsors to recover the cost of benefits that they've provided, including to take them to court or to refer them to the Attorney General for that recovery. So even though the order has not been signed, we're already seeing effects. People have been withdrawing from essential benefit programs like Medicaid and SNAP due to concerns about the leaked order. These include people who might be exempt from public charge altogether and people who are already lawful permanent residents who wouldn't be affected by a public charge determination. We are collecting stories about people who have acted out of fear of the order. Please send those stories to publiccharge@nilc.org. And just as a final reminder, the order has not been signed, nothing has changed. People should take advantage of the essential health care and nutrition program benefits they're eligible for.
Thanks, Gabrielle. And just a reminder to everyone to please send us your questions through the question box function as they come up, and we'll be collecting them throughout the webinar. Now I will pass the torch along to Karen Tumlin, the legal director at NILC, to speak about the litigation challenging the Muslim ban.
Great. Thanks, everybody. Can we move to the next slide when you have a chance? I'm going to talk briefly about where we are now with respect to the Muslim ban executive orders, focusing really on Muslim ban 2.0, which, as folks know, is the second executive order after the Trump administration had been dealt really stinging losses in the federal courts on the first executive order. And then I'm going to pass it over to my colleague Matt Adams at the Northwest Immigrants' Rights Project, who can talk about the Washington cases, including the litigation that they are bringing challenging the executive orders as well. So as folks know, the second executive order was, I like to describe it as, well, if it walks, talks, and walks like a duck, it is in fact a duck. So despite the fact that one of the countries was removed from one specific part of the executive order, that Iraq was removed from the portion of the executive order that many folks refer to as the travel ban, and has to deal with the prohibition for 90 days on the issuance of visas to nationals from now 6 specific countries: Iran, Libya, Somalia, Sudan, Syria, and Yemen. The rest of the executive order very much has the same intent that it originally did. In our minds, and of course in the minds of several courts that have now weighed in, the executive order is nothing more than a dressed up version of an attempt to disparage one particular religious group by the federal government, Islam. So what has been blocked by the courts? As folks know, at the stroke of, right past midnight on March 16th, the new executive order was meant to take effect. Lots of folks across the country, including Matt, who will speak in a little bit, and our organization, the ACLU, the CARE Coalition, the state of Hawaii, the state of Washington, and others had filed new legal paperwork to try to ensure that that new executive order was not allowed to take effect. And what we had was a couple of rulings that came down on March 15th and into the early morning of March 16th. The first one came from the district court in Hawaii. The second one came from the district court in Maryland. And I will give you a little bit of a lay of land of what has been blocked by the courts. So first, what folks call the travel ban provision, which is the prohibition on obtaining visas for 90 days for folks from 6 specific countries, has in fact remained blocked. So that, of course, is excellent news. In addition, and I think this is really important, that the temporary restraining order in Hawaii blocked for the first time 2 provisions that were in the original executive order and were in the revised executive order dealing with refugees. So first, the halt for 120 days on the entire U.S. refugee program worldwide. That has now finally been blocked, given the TRO that came out of Hawaii on March 15th. Secondly, the slashing of the refugee admissions number has also been blocked. Last year, President Obama set, which is done pursuant to the federal statute, the Refugee Act of 1980, he set the annual admissions limit on the number of refugees we were expected to admit to the United States for this fiscal year. That number was set at 110,000 in recognition of the fact that we are presently in the largest refugee crisis in history since World War II. The first and second executive orders drastically slashed that number by more than 50% to 50,000 refugees worldwide. And we know that this is having an immediate impact. Upwards of 38,000 refugees have already come into the United States in this fiscal year, but more than that, well over the number that would get us to the 50,000 were already approved, awaiting abroad to have their travel booked and to enter the United States. As a result of the first and second executive orders, the U.S. refugee program had shut down not only all travel bookings, but also all interviews for the refugee process. And so that of course is a concrete, immediate harm that had been coming to refugees worldwide, and is something that finally the Hawaii order takes aim at and should at least temporarily stop. So if we could go to the next slide, please. What this slide brings up is a little bit of a lay of the land of the various cases. So I've described primarily the Hawaii case, which the issue is it is a temporary restraining order. Right now there is discussion among the parties about whether or not that order, which temporary restraining orders typically only last approximately 2 weeks, whether or not that order can be considered what's called a preliminary injunction and remain in place and be appealed. So there is right now a hearing tentatively set in Honolulu to decide this question of whether or not the temporary restraining order will be extended or converted to a preliminary injunction, providing a bit more stability on the block of these provisions. That's set for Wednesday. In addition, in the International Refugee Assistance Project case that NILC is involved with our partners at the ACLU, we had what's called a preliminary injunction issued in the early morning hours of March 16th. Now, it only addresses the travel ban portion, but it does provide more stability on that block. We know, for example, unless the federal government gets a stay of that injunction out of Maryland while they seek review at the Fourth Circuit, which they are in fact trying to do, they're filing paperwork on that today, that the preliminary injunction on the travel ban would remain in place at least through our argument at the Fourth Circuit, which has now been set for May 8th. So that is really good news. But we need to watch what happens in Hawaii to see if the refugee provisions will also remain blocked. The last thing I would say before passing the floor to Matt, who can talk about his case and the Washington cases, is I would mention that this morning, unfortunately, we did have some bad news that came out of the Eastern District of Virginia, and in the case of Sarsour versus Trump, which is brought by the CARE Coalition nationally. They had also sought a preliminary injunction on the new executive order. The court there denied that motion, finding, among other things, that there was no violation of the Establishment Clause. And so obviously that will be another case that we'll need to be watching in the days to come. So with that, I would pass the floor to Matt and let him talk about his case in the Washington cases. Thanks so much, Matt.
Great, thank you. So I guess I would start off by saying the headline to this slide is Washington case, but to be clear, there are two cases in Washington. So I'm going to be talking about our case, which is Ali versus Ashcroft, which was filed by Northwest Immigrant Rights Project, American Immigration Council, and the National Immigration Project. But on the same day, in fact, just a couple hours after we filed our lawsuit on January 30th, the state of Washington filed a parallel lawsuit, which actually, as I'll explain a little bit more, encompassed a broader swath of the original executive order. And so most of the attention the first round was on the Washington state lawsuit because they immediately sought a TRO and obtained a TRO of enjoining the federal government from moving forward and giving effect to the original executive order. But then, as we know, Trump came out with a second executive order on March 6th. Now, prior to that, in the Ali case, we had filed a motion for class certification and a motion for preliminary injunctive relief. But then, as everyone knows, the TRO that was initially issued on behalf of Washington State was then interpreted to be a preliminary injunction by the Ninth Circuit and was set for it. So the initial TRO was upheld and it was set for briefing. And despite a lot of bluster from the Trump administration about appealing it and challenging it all the way and ultimately prevailing, they actually withdrew their challenge and instead opted to go the second round where they issued their second executive order. And on March 10th, in response to that second executive order, we filed an amended complaint, and at the same time we filed a second motion for class certification and as well a motion seeking temporary restraining order and preliminary injunctive relief. Now, shortly after our arguments, about 20 minutes after our arguments, the state of Hawaii's case was successfully able to obtain an order of the issuing a TRO, and then shortly thereafter, as Karen said, in NILC's case in Maryland, they got a preliminary injunction as to the travel ban. And so what the judge did in our case, and then subsequently did as well in the state of Washington case, is said, I don't need to rule on your motions for a temporary restraining order or a preliminary injunction in light of what's happened in Hawaii. And so I'm going to hold off on those, and we'll move forward with the rest of the case. So you'll be able to move forward on your motion for class certification and discovery, and we're now in the midst of fighting with the government about that. But as to the TRO, that's on hold unless something happens in Hawaii. Then you can always come back and have it reinstated. But for now, there's nothing moving forward on the court with respect to the preliminary injunction motion. But as we said, we'll move forward and are moving forward with the rest of the case. So let's move on to the next slide. One thing I would highlight about our case is that it focuses only on immigrant visas, not non-immigrant visas or refugees. So that is to say it's not dealing with temporary visas, student visas, anything that's not an immigrant visa. And the reason for that is because we wanted to have a case that framed front and center the statutory ground for non-discrimination. But as you may or may not be aware, the non-discrimination clause in the Immigration Nationality Act at 202A1 only focuses on immigrant visas. And so while we bring the constitutional claims, standard rules of statutory construction and dealing with challenges to the Constitution require the court to first resolve a statutory claim. So we are hopeful that we could bring some teeth into that non-discrimination clause by focusing primarily on that and leaving to our allies the broader challenge that would address both non-immigrant visas and the provisions dealing with refugees. Now, that being said, there's other litigation also challenging the vetting clause. So there's portions of the executive order, the 2.0, that have not been enjoined that instruct the federal government to explore vetting as it applies to immigration benefits. And so we have yet to see how that's being defined. But there's a separate lawsuit that's also filed here in the Western District by Northwest Immigrant Rights Project, the ACLU, National Immigration Project, and Law Office of Stacey Tolchin that is focusing on those vetting requirements, those separate provisions of the executive order. But that pretty much lays out the scope of the land as far as what's happening in Washington. Similarly, the state of Washington is moving forward on their case, fighting over a discovery schedule, and that's where we're at. So I think without further ado, I'll turn it back over.
Hi again. Thank you, Matt. That was a really great update from Matt and Karen. And now we will go ahead and pass it along to Alvaro Huerta here in the LA office to update us on the Louisiana marriage case.
Hey folks, name's Alvaro Huerta here in the Los Angeles office of NIL. So the marriage case that we've been working on for actually quite a while, which we filed back in October of 2016, is called Lowe v. Gee. It's a result of a Louisiana legislature when it passed a act called Act 436, which was signed by then Governor Bobby Jindal back in 2015. The law, as it works, adds a number of documentary requirements for obtaining a marriage license, and a lot of those were targeted at immigrant communities specifically. So they, for example, require a passport for folks who don't have a Social Security number. They require a birth certificate of all applicants, but in this case, they do not allow someone who doesn't have a birth certificate to get that requirement waived. Our client, Viet Victor Anvo, was born in an Indonesian refugee camp after his parents fled Vietnam. So he did not have a birth certificate because he was born in a refugee camp, and he cannot get a birth certificate. It's just impossible for him to do so. Act 36, as I mentioned, the law before Act 36 allowed everyone who could not get a birth certificate to do so by going in front of a judge and showing other proof of their identity of birth facts, and then they could get that requirement waived. Act 36 took away that waiver process from only foreign-born people. So everyone born outside of the U.S. or its territories was no longer able to get the birth certificate requirement waived. So we realized that this was unconstitutional. Clearly, right? It discriminated against foreign-born people. It treated them differently than citizens. And this was about a fundamental right. It was about the fundamental right to get married to the person that you love. So along with our co-counsel, our close partners at the New Orleans Workers Center for Racial Justice, and the pro bono services of the law firm Skadden Arps, Slate, Meagher, and Flom, we sued the state of Louisiana. We sued the state and the clerks who actually denied the licenses to our client, Mr. Vo. And we challenged the law on 3 bases. We challenged it based on the Equal Protection Clause, the Due Process Clause, and the Supremacy Clauses of the U.S. Constitution. Our claims were that Act 436 discriminates against foreign-born individuals unconstitutionally, meaning that it has its national origin impact or treats people differently based on their national origin. It also denies the fundamental right to marry, which we know, has been reiterated over and over by the Supreme Court as a fundamental right. We're 50 years away from the Loving v. Virginia decision that made it illegal to deny marriage licenses or the opportunity to get married to interracial couples, and we're just 2 years away from the Burgess v. Hodges decision, which extended that right to marry or reiterated that that right is a fundamental right regardless of your sexual orientation. We also said that the law is preempted because it violates the federal immigration laws in its attempt to regulate in an area that the Congress, the federal government, has said is exclusively in the jurisdiction of the federal government. And we won. Just this week, on Wednesday, in the Eastern District of Louisiana, a federal court, the judge said that Louisiana was doing something unconstitutional and entered just yesterday an order granting our preliminary injunction motion, which means that our client, Mr. Vo, can get married to his fiancée legally. The judge made it very clear that the law is unconstitutional if it burdens anyone who might be burdened by these requirements. So it actually extends beyond our client to anyone in Louisiana who seeks to marry and who cannot provide the required documents that Act 46 requires, which is a great win. We're very excited. It doesn't mean the case is over, of course. We want to make sure that that preliminary injunction becomes permanent. And we want to make sure that no one is affected by the provisions of Act 436, regardless of their country of origin, of their immigration status. So we're going to continue this fight to make sure that everyone in the state of Louisiana is able to marry the person that they love, and that other states who try to consider doing similar things, passing similar requirements, are put on notice so that they realize that this is clearly an unconstitutional act, and we will not stand for it.
Great. Thanks, Avo. And now we are going to move to the question and answer session here. So please continue to type in your questions, and we will, I'll delegate the question to the appropriate panelists to answer the question. We can go ahead and get started. We have a few questions about the leaked public charge executive order. So I'll ask these to Gabrielle. The first question is, would the leaked executive order affect the use of WIC, the WIC program? And maybe you could explain it just in case everyone doesn't know what the WIC program is.
Okay, the WIC program is a program for infants and mothers, and it provides vouchers that enable people to obtain nutritious food, and it is an income-based federal program. So on the face of the executive order, it is possible that it could extend to the WIC program, but we just don't know how broad the order will go, and again, if it will be signed at all.
Okay. Another question related to the executive order is whether the executive order would affect lawful permanent residents.
Okay. So public charge is both a ground for denial of admission as well as for deportation. And I stayed away from talking about deportation because there are a lot of unknowns about how the long-standing statutory deportation provision would be affected by the executive order. The deportation provision for public charge says that if a person receives benefits within their first 5 years in the country for reasons that they can't show for reasons that existed before they came to the country, then that would be a ground for deportation. Deportations on the grounds of public charge are exceedingly rare, and they only, under current policy, the only situation where a person can be deported on public charge grounds is where they have received a benefit. And remember that immigrants who would be affected by public charge determination, so mostly people who are eligible to adjust to LPR status, who are not refugees, asylees, other categories of people who are exempted because they basically came fleeing persecution, those people are not eligible for most federal benefits during their first 5 years in the country. So the person received benefits during their first 5 years. There was a demand for repayment. There was a final demand for repayment entered, and the person did not repay. So an LPR, if that person were to receive a benefit that the order reached during their first 5 years in the country and could not show that their reason for needing the benefit, such as an accident, a pregnancy, a job loss, arose after they came to the country, there's a theoretical risk of deportation, but I really don't want people to panic about that because there's just a lot that we don't know about how that would be applied if the order were signed.
Great. Difficult question to answer. Another question about the public charge executive order is whether it may be applied to U.S. citizens who are members of mixed status families.
So public charge is an individual, not a family level determination. The one way that citizens could be affected by the public charge order would be if they were a sponsor. So the way that the family immigration system works is that people petition for their family members, and that petitioner is required to sign an affidavit of support and act as a sponsor for the person that they're petitioning for. And under the executive order, those affidavits of support, which on their face are currently enforceable but are actually rarely enforced because it's more expensive to try to recapture any benefits from the sponsors than the cost of the benefits themselves. Under the order, federal agencies would be required to pursue sponsors for the value of any benefits that their sponsored immigrants had received. And in that way, a U.S. citizen who was a sponsor could be affected. And I just want to note that this is really a draconian order, if that wasn't obvious to everyone already.
We have a few more questions on the public charge executive order. So one question is there any concern that if the leaked executive order is eventually issued, that the people who took advice to continue using benefits might be harmed?
Once people have used benefits, if they're asked about the use of those benefits, they'll have to say yes. So our feeling is that it's better for people to continue taking advantage of needed services than worry that the quantity of services or the time period that they receive services would have an adverse impact on their public charge determination. But of course, everybody should make a decision based on their own circumstances, and with the awareness that the public charge test will look at all facts and circumstances related to the person's ability to support themselves. So a person who was using benefits and had a long-term period of unemployment or some other factor that might lead to an adverse determination might want to consider refraining from applying to adjust to LPR status until they had put that benefit used further behind them.
And is there any concern that the information about the use of benefits that was already collected or may be collected could be used to approve or disapprove an application in the future under this order?
In the future or now?
Well, if the order is implemented.
That the use of benefits could be considered retroactively. That is a possibility. But, again, once people have used benefits, they're going to have to acknowledge that they have done that. So disenrolling on balance is probably less beneficial to them than continuing to get services they need.
I'm going to ask a question to mix it up a little bit about to either Karen or Matt regarding the recent activity on the various Muslim ban cases. Do you think that the new order in the CARE case might affect how the other cases move forward, or how do you foresee that playing out?
I personally think it's too early to know. I mean, the decision just came down, and I think we'll all, look to see what CARE says about what their next moves would be. So I think it's a little early to predict, and I also think there's a good number of cases moving already.
And just to state what might be the obvious, but since we already have reporters asking this, is that the fact that the TRO was denied there does nothing to impact the preliminary injunction that NILC won or that the state of Hawaii won. So that has no impact there other than providing the government some fodder for their arguments on appeal.
Thanks, Karen and Matt. So we are still getting a lot of questions on the leaked public charge executive order. So I'll go ahead and go back to Gabrielle and ask a couple more questions. Under the leaked executive order, is there an exemption for refugees? Because the person who asked the question pointed out that the Office of Refugee Resettlement requires refugees to sign up for public benefits.
Yes, there are a number of categories of people that are exempt from the public charge test, and refugees are included.
Great. Another question that just came in is, immigrant minors are currently eligible for Medi-Cal. So could a minor's use of Medi-Cal impact the minor's ability to adjust status based on asylum or special immigrant juvenile status?
Asylees are also exempt from public charge, and I believe that people with SIJS are also exempt. I'm quickly looking this up, so maybe you can go to another question.
Sure. This person said, I'm not sure if this is the correct place for this question, so feel free to let me know, Gabrielle, but could anyone comment on the AHCA and any changes to immigrant eligibility to benefits under that bill?
Do you want to take that, Alvaro, or should I take it?
Oh, yeah.
Okay, so the AHCA, in addition to decimating Medicaid, it would change immigrant eligibility to receive tax credits when purchasing health plans through an exchange. Currently, all lawfully present immigrants are eligible to receive benefits for which their income qualifies them through the exchanges, both cost-sharing reductions and advanced premium tax credits to help pay the monthly cost of insurance. The HCA would change that and limit eligibility only to immigrants who were deemed qualified under the welfare reform laws that went into effect in 1996. And those are primarily lawful permanent residents and refugees, asylees, and other people who came fleeing persecution.
Okay. Another question is, could the leaked executive order impact people who are already enrolled in Medicaid? Because the current terms and conditions of the Medicaid application state that the applicant will not be considered a public charge.
Again, we don't know the scope of the order. Theoretically, it could. Even if it does extend to Medicaid, we also don't know whether it would be considered retroactively.
I'm not sure if your answer to the last question encompassed this, but would the public charge order, if signed, affect emergency Medicaid recipients?
We just don't know. Currently, emergency services are not considered for public charge. They're a non-cash benefit, so for that reason, and also as a matter of public policy, but we don't know. Now, people who are receiving emergency Medicaid when we talk about emergency Medicaid, we're usually talking about a restricted scope program that is only available to people whose immigration status doesn't qualify them for another kind of health coverage. So those people would typically not have a path to adjust to LPR status unless some other path opened up. You know, the fear of not being able to adjust to become an LPR in the future should not deter people from getting emergency medical services when they need them.
Another question on the public charge executive order. If someone is receiving a school scholarship or state aid for school, would that be considered under the leaked executive order?
Only federal benefits would be affected. And again, we don't know the scope. We don't know if federal financial aid for education would be affected. It would be a perverse interpretation if it were, because education prepares people to, you know, essentially earn more money in the future, which would be contrary to being a public charge.
Okay. And you may have already slightly covered this, but we are getting this question a lot, so phrased a different way perhaps. With the leaked executive order, could the green card of a person who's already a lawful permanent resident be revoked if the person has used public benefits in the past?
No, there's no basis for revocation of a green card. Okay, and I know that I mentioned a few times that certain people are exempt from the public charge determination. If you go to our website, there's a document that's called Federal Guidance on Public Charge, When is it Safe to Use Public Benefits? And on page 4 of that document, there's a list of categories of people that are not subject to the public charge test. And in addition to refugees and asylees, that includes trafficking victims, domestic violence survivors who've filed a self-petition under the Violence Against Women Act, as well as their qualifying spouses or children, U visa holders or applicants, and special immigrant juveniles, and a number of other categories of people.
Great, and I think given the volume of questions we're getting on this topic, we will, in the email we send out on Monday, we'll include a link to that as well so that folks who registered can access that. Another question on the public charge executive order.
Obviously, I wasn't clear.
No, I think that there's a lot of interest in it. If the public charge, the current law on public charge is statutory, what is the point of the Trump administration trying to put out an executive order, and I guess what ultimate effect could it even have?
That's a great question. So just to put that in a broader context. So executive orders have the full force of law when they are issued according to authority that's delegated to the President by the Constitution or the Congress. They cannot be contrary to existing law. They obviously cannot be unconstitutional, as we have seen with the Muslim ban, and they can be overridden by subsequent legislative activity in Congress. So the purpose of the order, in my opinion, is to go further than the existing enforcement orders in terrorizing the community. It is to paint immigrants as burdens on society, and it is to deter people from using public benefits to which they are entitled and for which the community as a whole benefits. And it is to change our family-based immigration system by deterring people from sponsoring their relatives. And just to remind everyone, or just to state the obvious, these are lawfully present people we're talking about with this order. This is a step further than we've really seen from this administration.
Another related question that either Gabrielle or if any of the other panelists want to chime in on this one, given this, all this going on, the leaked order and the possibility of all these changes, is there anything new being done on the state level or any plans to further protect immigrants who may
seek help or public benefits?
We don't have the right people in the room for this, but on the state level in California, there is a bill that I believe the legislature is still considering called the California Trust Act, which reiterates existing protections in the law as well as fills some holes related to the confidentiality of information that's provided on any kind, provided to public agencies, both in benefit application processes and other contexts.
Great. Just a reminder to please continue sending questions. If you have questions on the public charge executive order or on the congressional budget, the Muslim and refugee ban executive order 2.0 and the legal cases challenging that, or the Louisiana marriage case. And our panelists will be happy to answer those. Well, we're not getting any new questions now, so I think we can go ahead and wrap up early. Thank you all again for joining, and once again, this webinar was recorded, and the recording, the slides, and a link to our public benefits page on our website will be sent out in an email on Monday. Thanks, everyone.